spent in jail waiting the trial or disposition of the case, but other than that, you have to serve every day. You understand that?
Yes, sir.
Okay. Now, under the law, the court could impose consecutive sentences if you are convicted of both of these offenses. So that means that the maximum could be up to 8 years on each, or 16 years. There could also be a maximum fine of $15,000 in each, so it could make it a total of $30,000. There is a mandatory fine in each case of $7,500, and you could get a license suspension of 6 months to 5 years on each count. You understand that?
Yes, sir.
And other than these charges, are you facing any felony charges in any other jurisdiction?
No, sir.
And are you currently on probation, parole, community control, or post-release control for a felony?
No, sir.
All right, now, under the law, Mr. Elliott, if you plead guilty, the Adult Parole Authority can decide that whatever the minimum sentence is, or whatever the sentence is ordered by the court, which again could be any number between 2 and 8, and it could be consecutive. But as to one of those 2 counts, the Adult Parole Authority could decide to extend your period of incarceration by up to 50%. Both of these offenses qualify for that, but under the law, they can only extend on 1 count. And so it could mean that if assuming, let's say the worst case scenario, let's say you got 8 years on each count consecutive. That would be 16 years. The parole authority then could extend one of those sentences of 8 years by up to 50%. So 50% or half of 8 is 4. So that means on one of the counts, they could make you serve 12 years. On the other one, it can only be the maximum of 8. So that means the potential maximum sentence is 20 years. Now, the minimum sentence could be 2 years, and so that means they could actually extend it by up to a year, meaning 3 years. So that's the way that works. You understand that?
Yes, sir.
Now, under the law, Mr. Elliott, once if you are convicted of this offense and are sentenced, and you have to be sentenced to prison, there's no option. There can be no probation or community control. So once you complete whatever sentence is ordered by the court, and any extension of up to 1/2 of the sentence on 1 count, if that is ordered by a DRC, it will be mandatory that you be placed under post-release control supervision, under the supervision of a parole officer in a term set by the Adult Parole Authority for a period of at least 18 months and a maximum of 3 years as determined by the APA. And what that means is that if you violate any of those conditions that they have set forth, then they could return you to prison, make you serve an additional period, even though you served the entire term that was ordered by the court, of up to 9 months for any single violation, up to a maximum or cap of half of your prison term for all violations. But if you commit a new felony, then in addition to whatever sentence the judge in the new case could order, that judge could also sentence you for committing that violation while under post-release control in this case to an additional period of a year, whatever time is left on that period of post-release control, whichever is greater. And if that occurred, that would have to be served consecutively to the sentence in the new case. Do you understand that?
Yes, sir.
All right, now, the charge in count 1 reads that on or about September 15, 2022 in this county, you did knowingly sell or offer to sell methamphetamine or Schedule II controlled substance amount equal to or exceeding bulk amount less than 5 times bulk amount in the vicinity of a juvenile. Count 5 alleges the same thing except that it occurred on September 19, 2022, but otherwise the same offense. And so that's the charge, again, second-degree felony with the penalties I've just described for you. Now, Mr. Elliott, do you understand what it is you've been charged with, what the state said you did, when, where, and how they alleged that you did it?
Yes, sir.
And you understand the maximum penalty for these offenses?
Yes, sir.
Now, have you discussed the nature of the charge, the evidence in the case, possible legal issues in the case, the possible defenses you could try to raise at trial, and possible outcomes of a trial with your attorney?
Yes, sir.
Are you satisfied with his advice and confidence in this matter?
Yes, sir, I do.
Are you under the influence of any types of drugs or alcohol at this time?
No, sir.
Have any threats been made to make you plead guilty here today?
No, sir.
Now on page 2, there are, actually page 3, there are several lines printed in bold and underlined that read as follows. Defendant will enter a plea of guilty to count 1 and count 5. State will dismiss remaining counts. State defense jointly recommend 3 years mandatory incarceration on count 1, consecutive to 3 years mandatory incarceration on count 5. Defendant agrees to cooperate fully with the task force and cooperate fully in the prosecution of all co-defendants. Defendant agrees to repay by money to the task force as follows: $100 joint and several with Jamie A. Weiskup and $380 alone. Now, is that your understanding of the agreement?
Yes, sir.
So that calls for a mandatory prison term of 6 years, all of which must be served, and the maximum could be 9 years because the DRC could extend that by half on one of those counts of 3 years. You understand that?
Yes, sir.
Okay. Now, under the law, the matter of sentence is up to the judge, and so if you plead guilty, I don't have to follow that recommendation. I could impose any sentence between 2 and 8 years that I felt was appropriate, run them consecutive. I could fine you the maximum and suspend your license. Do you understand that?
Yes, sir.
Now, Mr. Elliott, do you hold any license or certification from any state governmental agency that regulates any occupation or profession?
No, sir.
You have certain constitutional rights you must understand before I can accept a plea. In this case, first you have a right to have an attorney. Mr. Armstrong was appointed to represent you, not simply to work the case out, but to provide any defense that could be available to you under the law that you'd like him to provide. So if you decide that you do not want to plead guilty, that you would rather defend against this charge, he will continue to represent you, including a trial, if that's what you want. Do you understand that?
Yes, sir.
Right now, under the Constitution, you have a right to have a jury trial in this matter, in which 12 people will be selected from a group of citizens that live in Highland County that are summoned for jury duty on your trial date. After they are selected, the evidence will be presented. They'd be instructed on the law by the court. And then that jury of 12 people would have to decide on a verdict in each case to determine, would have to determine that by unanimous verdict, meaning all 12 would have to agree as to a verdict in each case. Now, if you didn't want to have a jury trial, but you didn't want to plead guilty, you can waive in writing, which means to give up your right to have a jury trial, and then you would have what's called a court or bench trial, meaning instead of a jury hearing the evidence, the judge would hear the evidence, apply the law, and decide whether or not the state proves your guilt. Do you understand that?
Yes, sir.
Under the Constitution, you have the right to use the power of this court to compel or force witnesses to come into court to testify for you, just like the state. So if you have witnesses you're not certain are going to come in voluntarily, at your request, the court issues a court order called a subpoena, and that forces those witnesses to come to court to be available to testify if you want them to, even though they don't want to be here, which is the same way the state's witnesses are required to come to court to testify against you. Do you understand that?
Yes, sir.
And under the Constitution, you have a privilege against self-incrimination, which means you cannot be forced to give evidence in this matter at any time, including trial. No one can ever make you testify. The prosecutor can't, the judge can't, it's your decision. If you decide not to testify, the fact that you did not testify cannot be used against you in any way by any person at any time, and no one's even allowed to comment about it except in one situation. If there's a jury trial and you don't testify, the judge instructs the jury because that is your right. They cannot consider it for any purpose. Do you understand that?
Yes, sir.
Right now, under the Constitution, you are presumed innocent of each of these charges until proven guilty by the state of Ohio on every essential element of each offense. So what that means is that the burden of proof isn't on you to try to show you're not guilty simply because you've been accused of these crimes. In fact, under the law, you're not required to present any defense at all. You may, but you're not required to. But whether you do or not, the burden of proof will remain upon the state of Ohio to prove your guilt on every essential element of each offense by proof beyond a reasonable doubt, which is the highest burden of proof that's known under the law. Do you understand that?
Yes, sir.
Now, originally you entered a plea of not guilty. Not guilty plea denied the allegation in the indictment, denied you committed any crime, and it exercised or invoked all the rights I've just described. If you change your plea from not guilty to guilty, as to counts 1 and 5, that is the complete opposite of the not guilty plea. The guilty plea admits the allegation in the indictment in those 2 counts, admit that they're a crime, and that you committed that crime. And that plea waives or gives up all the rights that I've just explained for you today, except your right to have an attorney. You always have a right to have an attorney, no matter what your plea. But with that exception, the plea of guilty would waive or give up your right to a jury or a court trial. It would waive or give up your right to confront the witnesses and to cross-examine them through your attorney in open court. It would waive or give up your right to use the power of the court to compel or force witnesses to come to court to testify on your behalf, the same as the state. It would waive or give up your privilege against self-incrimination because you're saying you're guilty. That's what's used to find you guilty. It would waive or give up your presumption of innocence because if you say you're guilty, the state's not required to prove you're guilty. It also waives or gives up any right to file an appeal you think you may have had up until this point in the case. Now, if you should be sentenced to the maximum sentence or under other certain limited circumstances, you can file an appeal, but that would have to be filed within 30 days of your sentencing entry being filed. Do you understand all of that?
Yes, sir.
And it also subjects you to being sentenced immediately by the court. You understand that?
Yes, sir.
Okay. And are you a U.S. citizen, Mr. Elliott?
Yes, sir.
Now, do you have any questions about the charge or the possible penalties? Either charge? Yep. You understand them?
Yes, sir.
Have any questions about the constitutional rights I've explained?
No, sir.
You understand those?
What?
Do you understand those?
Yes.
All right. Do you have any questions about the plea agreement?
No, sir.
You understand that?
Yeah.
Have any questions about the plea of guilty, what it means, and what will happen if you enter that plea here today?
Yes, sir.
All right. Do you have any questions you would like to ask Mr. Armentrout or anything you need to talk to him about?
No, sir, I don't.
Okay. Have any questions about anything I've explained here today?
No, sir.
All right. Then, Mr. Elliott, is it your decision to withdraw your not guilty plea and plead guilty to the charges in count 1 and count 5 as I've just gone over in this plea agreement?
Yes, sir.
All right. Then, as to count 1, which alleges that on or about September 15, 2022 in Highland County, Ohio, you did knowingly sell or offer to sell methamphetamine, a Schedule II controlled substance, an amount equal to or exceeding bulk amount but less than 5 times bulk amount in the vicinity of a juvenile in violation of Section 2925.03A1, the charge of aggravated trafficking of methamphetamine in the vicinity of a juvenile, a second-degree felony carrying a mandatory prison term between 2 and 8 years is set by the judge with a maximum of up to 50% as determined by the Department of Rehabilitation and Corrections. Fine of $15,000, a mandatory fine of $7,500, and a possible license suspension of 6 months to 5 years. How do you plead?
Guilty.
Then as to count 5, which reads the same, except that it occurred on September 19, 2022, otherwise the same penalty and the same offense. How do you plead?
Guilty.
All right, thank you. The court finds on this day in open court, defendant was advised of all of his constitutional rights, made a knowing, intelligent, voluntary waiver of the same pursuant to Criminal 11. Please accept it. Order filed. Defendant is found guilty of the offense of in count 1 and count 5 as stated in those counts of the indictment. Counts 2 to 4, and 6 through 10 are dismissed as to this defendant. Now, inasmuch as the law requires a mandatory prison term on these offenses, I'm not going to order a pre-sentence report. I'll go ahead and proceed with sentencing. All right, on behalf of the state, Mr. King.
Only what is contained in the plea, Mr. Honor.
All right, Mr. Armentrout, anything you'd like to say?
I would ask the court to call the recommendation made by the state. Speaking to Mr. Elliott, going through the evidence, he didn't make any of the excuses we see some of the times. He saw the evidence, he saw the videos, merely acknowledged what he had done. I would ask the court to call the hearing.
All right, Mr. Elliott, anything you'd like to say?
No, Your Honor.
Looks like this indictment was filed on the 6th. Were you arrested on the 14th of June, Mr. Elliott?
Yes, I do believe so.
All right. Actually, it says the 10th here on the return. All right. All right, well, then it's the judgment order of the court that defendant be and is hereby sentenced to a mandatory term of 3 years on counts 1 and 5, and they're to be ordered to be served consecutively to each other for a total of 6 mandatory years. The court finds that defendant has an extensive previous felony record, including a previous prison term for aggravated trafficking and aggravated possession and grand theft, and that the sentence that's being imposed is not disproportionate to the seriousness of the offense, and that one single term would not accurately reflect the seriousness of the offenses of the harm done. and the criminal record demonstrates that the defendant's consecutive sentence is necessary for the protection of the public. Now, according to my calculations, with an arrest date of June the 10th, that means that Mr. Elliott is entitled to 52 days of jail time credit. Now, upon completion of this, and again, Mr. Elliott, it is the court sentence of 3 years on each consecutive, and as to one of those counts, that could include extending it up to an additional year and a half. So that means it's a possible sentence of 6 to 7.5 years. Six mandatory, could be as much as 7.5. Now, upon completion of that prison term, the adult parole authority must put you under post-release control supervision for a period of at least 18 months and up to a maximum of 3 years as they determine. You'll be supervised by a parole officer in the terms they set. If during that period of time they find that you have failed to comply, they can return you to prison to make you serve an additional period of up to 9 months for any single violation, up to a maximum of half of your prison term for all violations. But should you commit a new felony while under post-release control, then in addition, whatever sentence a judge in the new case can impose upon you, that judge is also authorized to sentence you to an additional period of 1 year or whatever time is left on the period of post-release control, whichever is greater, for committing that offense while under post-release control in this case. And that sentence would have to be served consecutively to sentence in the new case. Now, has there been any change in your financial circumstances since, did you employ Mr. Armentrout? Okay, you're appointed, okay. So has been any change in circumstances since you filed your financial disclosure form?
No, sir.
All right, then the court will find the defendant's not able to pay the mandatory fine, and there's no likelihood he'll be able to do so in the immediate future, and therefore the court will waive that. You are also ordered to pay the court costs, which judgment, grant, and execution ordered Mr. Elliott. If you fail to do that, the clerk of courts can collect that through various means, including levying on bank accounts, wages, earnings, or other assets you may have. If that doesn't collect it, then once you get out of prison, not while you're in prison, but once you complete the prison term, you could do community service in this county and be given credit by the court for each hour you work, and an hourly rate set by the court. Each hour you work will reduce the judgment until that was paid in full. Now, pursuant to the plea agreement, it's also ordered as part of the sentence that you pay restitution to the Highland County Task Force in the amount of $100 joint and severally with a Jamie Weiscup, and an additional $380 on your own. Those payments can be made through the victim witness restitution escrow account, and you'll pay any service fees associated with that. All right, is there anything further from counsel? All right, Mr. King, we're going to be arraigning Mr. Harcourt if you had a chance to notify the alleged victim.
Attempted to, he's at work, he can't talk on his phone, and send a text message.
Okay. All right, officer, if you'll bring in Zachary Harcourt, please. All right, are you Zachary Evan Harcourt?
Yes, sir.
All right, this is case number 23 CR 128, State of Ohio versus Zachary Evan Harcourt. Mr. Harcourt's appearing for an arraignment after being arrested on a capious for failure to appear after being issued a summons for an arraignment. The Assistant Prosecuting Attorney, Adam King, is present. And my understanding, Mr. King, is you did attempt to notify the victim that he's at work and cannot talk on the phone.
Yes, sir, Your Honor.
All right. Well, based on the fact that he's employed, wouldn't be likely to be available then at any other time, the court will find that that's sufficient to comply with the statutory rights of the alleged victim, and we'll go ahead and proceed with this. Mr. Harcourt, you were indicted by the grand jury back on July the 11th on a charge of receiving stolen property, 4th-degree felony. It alleges that on or about May 15, 2023 in Highland County, Ohio, You did receive, retain, or dispose of a 1998 Honda Accord, a motor vehicle that belonged to another, knowing or have reasonable cause to believe it had been obtained through the commission of a theft offense. That's a fourth-degree felony, which if convicted, carries a possible prison term of between 6 and 18 months and a fine of $5,000. Now, you are entitled to have an attorney to represent you in this matter, and I don't see a financial disclosure form here. Are you going to hire your own attorney?
I cannot afford one.
Okay. Did you fill out, well, wait a minute, maybe it's, here it is, it's attached to the arraignment entry. I found it. All right.
Yes, they sent me one.
Pardon me?
I was asking if I had permission, if I could tell you something.
Well, I'll give you a chance to speak. Right now, I have a different agenda. All right, so everything on this form correct, Mr. Harcourt?
Yes, sir.
And when was the last time you were employed?
About 3 months ago.
All right,
Because I'm seeking out treatment right now.
okay. All right, well, the court then will find that you are entitled to appointed counsel. And is this the first time you've been in court on this particular charge?
It's the first time I've been on it before. When I was,
I asked you if this was the first time you've been in court on this charge. The answer to that is yes or no.
well, I don't know because I was charged on level 5 before I got to level 4.
Okay. Well, who was your attorney in that case?
Kirk.
All
Dennis
right.
Kirk.
All right. Court will then appoint Mr. Kirk to represent you in this case and enter a not guilty plea on your behalf. Well, actually, this says that Mr. Armentrout represented you at the at that hearing, at the earlier hearing on this case.
Still who?
William Armentrout?
I guess, I don't know if that's his name or not, but I was told it was going to be Kirk.
Well, that's who it was before, so I'll appoint him instead since he would be more familiar with the case. All right. Now, let me look here. All right, now you would mention something about you were seeking treatment. What does that mean?
Well, under this case, the judge was telling me he was going to sentence me 90 days out so I can seek treatment to try to get some type of rehab or assessment. And I was arrested in court after I was leaving for Clinton County, which is what I got this FTA for. Is I don't recall getting the summons or anything, because I was in Clinton County on the 24th. And
24th of what? 24th of what month?
Of this month.
All right, you were served with this on the 11th of July.
I know that, but I was arrested here for Clinton County, and when I get on the court online to look up to see when the court dates are.
All right, so you say you were in Clinton County on July 24th or 26th, the date of this arraignment?
No, I had a court date on the 24th in Clinton County, and that was the last thing that shows up online as a court date.
Well, this isn't Clinton County. Where were you on July the 26th?
I was currently at home at that day.
Okay, all right, that's all right. I got you now. So you're not in treatment then, are you?
Well, I was waiting on the bed though.
Okay, and where is that?
Down in Springfield, Ohio.
Okay, all right. Well, the court's going to set a bail review hearing for you. Let's see. It'll have to be tomorrow afternoon. So that'll be August the 3rd at 3 o'clock p.m. We'll do that by Zoom. We will set the first pretrial in this case for August the 16th at 1:30 p.m. The final pretrial will be set for September the 6th at 1:00 p.m. And the trial date will be set for September 25 at 8 a.m. Bond will be set in the amount of $2,500 plus your own recognizance, which is your promise to appear. If you fail to appear, you could be prosecuted for an additional felony and if convicted, sentenced no matter what happens in this case. You'll be required to pay a deposit of $171 prior to release to cover the statutorily required fees. If you make bond, you'll report to the probation department immediately upon your release. Report to them once a week for 4 weeks, and after that, as they determine, undergo random drug testing they may order, provide phone numbers for home, cell, employer, have no contact with the alleged victim. Recommended by probation, be evaluated for substance abuse and mental health issues. If any treatment is indicated, you're to enroll in and follow that during the period of this action. You'll also be under house arrest at your residence at 6798 Heathermore Trail in Hillsborough, meaning you have to be there at all times unless you're working, going to and from work, medical appointments, court proceedings, in this or any other case, appointment with an attorney or probation officer in this or any other case. Other than that, you have to be there at all times. And if you fail to comply, that bond could be revoked. You can be held till further order of the court. You have any questions, Mr. Harcourt?
Yes, Your Honor.
What is it?
I was wanting to know how, because whenever the charge came about, I had a title that was signed and notarized.
Well, that gets to the merits of the case. This isn't a trial, so I can't, I don't know anything about your charge. I just know what I read. I'm not the prosecutor, I'm not the sheriff, so I can't answer those questions. You need to talk to your attorney. He'll get discovery and he can discuss the charge with you.
So I'm not allowed to get an OR bond at this time?
No, I said what the bond was. You didn't show up for an arraignment, so I'm not going to just let you go walk out the door in an OR when you didn't show up originally on a summons.
I understand that, but I show up for every court date.
No, you don't. You didn't show up for this one. So we're not going to argue it. I'm not your grandmother. You don't get to talk back to me. So that's my ruling. All right? Thank you. Good afternoon.
How are you?
Okay. Waiting on
I'm
Mr.
Margo Miola, by the way, Your Honor.
Okay, just a minute. We're waiting to get everybody on the record here. Get everybody logged in. Mr. Thompson, you'll need to go get a coat on. This is a court hearing. Court rules require coats for hearings. Do you hear me, Mr. Thompson? No, apparently not. He's connecting the audio.
Everyone hear me now?
Yes, Mr. Thompson, you'll need to go put on a suit jacket or sport coat.
I apologize, sorry, I took it off because it's rather hot in my office.
All right. Who is Mr. Damon? Do either of you know?
Mr. Damon is a paralegal.
Okay. All right. Then we'll go ahead and proceed. This is case number 23 CV 103, Bobby Wagner et al. Versus Allstate Insurance. This is a hearing being conducted by Zoom on a motion by the defendant to bifurcate the bad faith claim in the complaint and to stay discovery. Mr. Thompson is appearing on behalf of the plaintiff, and Margo Miola, you're appearing for the defendant.
Yes, Your Honor.
Have you entered an appearance in this case previously, Ms. Miola? Because I haven't seen your name.
I apologize, Your Honor. Tom Glassman and I put these files together. My name was on the initial complaint. He had a sudden emergency, if you will, this afternoon and asked me to cover this since we do work these Allstate files together, Your Honor. So I so apologize. I don't realize if I have a formal notice, I can do that fairly quickly if the court prefers.
Yes, go ahead and enter an appearance because under the rules, you're not supposed to appear in cases if you haven't entered an appearance. So I'll give you the exception this time. All right.
Thank you, Your Honor. I appreciate that very much.
All right. I've reviewed the motion, and I'll note that this complaint consists of 2 counts. It's a breach of contract of insurance for failure to pay a claim, allegedly, to the insured. And then there is a count 2, bad faith. And the defendant's motion is to bifurcate the trial and to stay discovery. Now, the way I read the motion, it's not based upon the punitive damages pleading claim. You're not asking for separate trial under the statute for punitive damages, which is automatic if yes to that point. But you're asking for there to be a bifurcation of 2 separate independent claims. That's correct?
Yes, Your Honor.
Okay. All right. Well, I have reviewed the pleadings and everything. Is there anything else you would like to add on behalf of your motion, your client's motion, Ms. Miola?
Your Honor, I reviewed the briefing that has been submitted to the court, and I do think it was pretty thorough, Your Honor. I don't want to waste any more of your time. I'm sure that you have a good handle on what those issues are. So nothing else that I would add to that.
All right. Mr. Thompson, anything else you'd like to add?
No, Your Honor, I think the briefing was fairly thorough in this case, covered all the bases.
All right. Well, as an aside, I'll note that there's a pleading in paragraph 20 on the first complaint, first claim for punitive damages. That's a breach of contract, and unless the law has changed, to my knowledge, you can't recover punitive damages as a breach of contract because all breaches of contract are considered intentional. But so to me, this ruling is strictly, or so to me, it would only be possible under paragraph 25 on count 2. But in reviewing this, it's the court's belief that these claims are fairly interconnected, and as such, it doesn't seem to the court to make sense to, and quite honestly, I have taken into consideration the court schedule too. It doesn't make any sense to me that we would have a separate trial with a jury on the breach of contract, and then have to recess and have another trial set months down the road and have that jury come back and hear the other claim. So I'm not going to, and if you're proposing two separate juries, that's not going to happen either. That just makes no sense. If that were the case, you know, we'd have this happen all the time. It just doesn't make any sense, and I don't believe the law requires that. I don't think that there's been a showing under the case law that it's mandatory. It's up to the discretion of the court, and then this court's discretion, I'm going to deny the motion. I think that the claims are related. There are issues of privilege. That's another matter. In any case, we would hear that if there's a request for protective order in the discovery. But other than that, there's no reason in the judgment of the court that there would be any reason not to permit discovery. So the motion will be overruled, and the scheduling order of the court will remain in place. All right. Anything further from counsel? All right. Thank you.